Okay, well, everybody, welcome and thank you for participating in our estate planning webinar. We're really pleased that you are going to take some time to do this. I want to be respectful of your time. We'll get this done within the hour. For those of you that are on a lunch break of some kind, we don't want to take that whole time up. Feel free to eat and do whatever you want to do during the session. That's totally okay with us. Also, feel free to ask questions along the way. And I would ask, if you're going to ask questions, please do so by putting those into the chat, and we will address those at some point along the way during the webinar. So why don't we go ahead and get started? So I am your presenter today. My name is Mike Fiffick. I am the managing partner of Fiffick Law Group. We are the provider firm for the Legal Shield provider firm for the Commonwealth of Pennsylvania. We are one of about 40 provider firms across the country. And this presentation is going to make a lot of reference to Legal Shield because Legal Shield, we provide services for Legal Shield members in Pennsylvania. And one of the benefits that Legal Shield members gets is the preparation of a basic will, financial power of attorney, an advanced directive for healthcare. That's all part of their membership plan, and it typically doesn't cost them any extra money in order to have that done. And it's really such an effective, important thing to do to protect yourself and protect your family, in particular your family, to make sure that the assets that you've worked so hard for get to where you want them to get after you've passed away. So today we're going to learn about a variety of things. First, we're going to talk about what a will does. That might seem to be a pretty basic thing, but a lot of folks don't have a clear understanding of what a will does. We'll talk a little bit about what happens without a will, and we'll go through about 5 real life situations and talk to you about what happens in those situations when you don't have a will. I guarantee that one of those life situations will either be yours or a situation of somebody that's in your close proximity as a friend or an acquaintance or a business relationship. It'll be something that you understand and you can connect with. We'll talk about 3 really easy ways to get the process started of getting your wills done. It's not, it doesn't have to be a terrible thing that you keep putting off forever and ever. There are really easy ways to get the ball rolling on it. And then once you have initiated a request to have your wills done, we'll talk to you a little bit about what the process looks like from the provider firm perspective. So wills are oftentimes misunderstood and underappreciated. Lots of folks don't have a will. I think over half of Americans, the last time that I had checked, it's pretty consistent statistic, they don't have a will. And there are a variety of reasons for it. And we think that the number one reason is really just procrastination, right? It's just not something that's at the top of your list of things to do. So you kind of keep putting it off, or it's just in the back of your mind. And you realize that it's something that you should do, but you don't happen to get around to it. Folks may also feel that it's too expensive to get a will done. And, you know, getting your will done and the expense of getting your will done for folks who do not have Legal Shield is definitely something that needs to be taken into consideration. But in contrast to the costs associated with cleaning up a situation where you don't have a will, the costs are relatively low. So even if you don't have Legal Shield, the cost of getting a will are relatively low compared with sort of the mess and cleanup that can need to happen if you pass away without a will. And we'll talk a little bit more about that later. And then many people just don't understand why they need a will. It's not that I run into a lot of people who don't understand that they need a will or don't really understand why they need a will. So we'll talk a little bit about that too. But as I had mentioned before, the Legal Shield plan is a great solution for all of these problems. We make it easy to get it done. In most instances, it doesn't come with any additional cost. It's just covered by your membership fee. And we're really going to help you through the process of understanding why you need a will. You're going to feel good about getting that done. So let's talk a little bit about what a will does. In its most basic iteration, it distributes the distribution of your assets and the handling of your assets after you pass away. It's like a traffic cop. It gets what you have to those that you want to have your assets after you pass away. You can appoint somebody that you trust to manage your estate. That person is often called an executor, or if it's a female, an executrix. Sometimes it may be called a personal representative. All of those people are the same, but it's somebody that you trust, that you have confidence in knowing that they're going to get these things done for you. Very importantly, if you have children or somebody in your life that you're leaving money to that has special needs, you can appoint a person as a guardian to care for your children, to take care of them, your children will live with them, and also to care for the assets that you leave for them. A very, very important thing, especially in this day and age whenever there are so many marriages that end up in divorce, or we have lots of non-traditional relationships out there that have children involved. Very important for those situations in particular to have children. And you can also place age restrictions on minors' ability to access the money that you leave them with. I have yet to encounter anybody in my professional career who thinks that giving a substantial sum of money to an 18-year-old is a great idea. The vast majority of folks want to delay or defer their children's enjoyment of those assets for some period of time, at least 21, or maybe even have it left over a period of time. And will also allows you to make gifts to non-family members. And again, we have lots of blended families, non-traditional relationships. So this allows you to make gifts to a partner that you're not married to, or stepchildren or friends, a charity of some kind that's very important in your life. A will allows you to make these donations. So it's important to know what a will does, but it's also very important to understand the assets that a will does not control. And so a will not control the disposition of jointly titled assets. Your will does not trump titling of assets in a joint fashion. So the most common example of that is a joint bank account that you may have with a spouse or with a child. The titling of that account dictates what happens with the money in that account after you pass away. And in fact, the titling of that account dictates ownership of that money even during your lifetime. A lot of folks don't realize that putting a child's name on that bank account means that that child can withdraw half or even all of that money in that account. And if the child has a creditor that can collect a judgment against the child, that money could be at risk for that judgment creditor of your child. So it's not just your money. Lots of folks put children's names on bank accounts for convenience so that the child can sign checks on their behalf. There's a lot more to joint bank accounts than that. And so it's important to understand that the joint bank account will dictate where that money goes after you pass away. Another good example are deeds or real estate. If you have somebody's name on a deed and that deed says that the property is owned with rights of survivorship, that will dictate where the property goes after you pass away, and your will not trump that. So most married couples by default own property with rights of survivorship. So if you pass away, your surviving spouse will then have sole 100% ownership of the property. But if you have put a child on there, if the child is on there as a tenant with the right of survivorship, when you pass away, your interest in that property passes to that child by virtue of what the deed says, even if your will says something completely different. Your will does not control assets that have a beneficiary form associated with them. So individual retirement accounts, IRA, 401k, pension, annuities, life insurance policies, those types of assets can be passed to somebody at death by virtue of a beneficiary form. You don't have to fill out a beneficiary form for them, but most people do. And it's important to understand that whatever you put in that beneficiary form will dictate where that money goes after you pass away, even if your will is completely different or says something completely different. it's important to make the will and those beneficiary forms work together in concert with one another. Because most people think whenever they do a will, that's really the expression of how they want their estate. And I say that, use that term very generally, their estate meaning everything that they own. The will is typically an expression of how they want all of their assets to pass at the time of their death. And so we oftentimes, whenever we're doing a will for somebody, we will tell them, let's take a look at your beneficiary forms to make sure that those forms reflect exactly what your will says, so it all flows according to that plan that you had in your mind and that we put down in your will. And in particular, if there's a chance that those assets in those accounts, IRA, 401k, could go to a minor, somebody that's under 18, or to somebody who is under an age that you would want them to have the money. It's particularly important to make sure that those beneficiary forms direct money that would be going to those individuals into a trust that we have set up in your will to be administered until those folks are of an age that you think it would be appropriate for them to have that money. That's how they would work together. Your will also not control assets that are in a trust. And I say most of the time. Some people have living trusts, might also be called irrevocable or revocable living trusts. Um, your will not dictate what happens with assets in a trust. Now, I'll say most of the time, meaning if you're the beneficiary of a trust that somebody else set up and you're the beneficiary, sometimes those trusts give you what's called a power of appointment. And with a power of appointment, you can designate where the money that you're entitled to in that trust goes at the time of your death. So that would be one exception to this otherwise general rule. So let's talk a little bit about what happens when you don't have a will. And we're going to go through 5 life situations. And I find that knowing what happens without a will is very important for you to understand. It really brings a new sense of urgency to getting a will done, or to knowing that you need to get a will done. So finding out what happens without it in your life situation is going to help you understand how to prioritize this job. So first situation we'll talk about are blended families. There are lots of blended families these days, right? And those blended families may have children from a prior marriage or a prior relationship that are all brought together. Well, without a will, I'll just say that most folks in a marriage type situation, they want their spouse to have everything. And then they may want, after their spouse passes away, they may want the balance of their estate that's left over to be divided either amongst your biological children and your stepchildren, if you're close with them, or maybe that you want to just reserve that money to go to your biological children. Well, without a will, the first thing that's important for you to understand is that your surviving spouse is going to end up splitting your estate with the children from your prior relationship. And that can be particularly difficult if you own a home and not a whole lot of other assets after that. Without a will, your surviving spouse may find that he or she has to sell the house in order to satisfy the laws of intestate succession, leaving half or more of that money to your biological children. So it can be really a difficult situation. You also, without a will, aren't going to be able to designate a guardian for the assets left to your children. It's not going to necessarily be your surviving spouse. It may be your ex-spouse or the parent of your children that you have a relationship with, or maybe you're from whom you're estranged. And so you're really leaving everything to complete chance if you have a family, in particular a blended family, if you don't have a will. That can be a really, really devastating situation. Unmarried couples also have some risk if they die without a will. There are lots of unmarried couples out there. Folks are delaying, getting married for a long period of time. I've had a good friend that this happened to, that was in a long-term relationship with somebody. They were planning to get married, but they never really did. And I'm sure that my friend would have wanted his significant other to receive his entire estate. They were together, committed couple for a long time. He passed away unexpectedly without a will, and she ended up with no part of his estate. And financially, for her, at least in that situation, it was okay because she had been living independently. But emotionally, um, for that significant other to pass away and be left nothing, I am sure that he wouldn't have wanted that. And for her, I'm sure it was disappointing or emotionally difficult to have that happen. It just adds to the emotional burden of having a loved one pass away. But the survivor would get nothing. So there is no there is no common law marriage in Pennsylvania anymore. It is not recognized. So unmarried couples who think that they are in a common law marriage situation and would inherit from one another are really operating under a misunderstanding of the law. Pennsylvania does not recognized common law marriages any longer. That's been done away with for quite a few years. And there's no grandfathering in either, that if you were in this committed relationship before that period of time, that you're grandfathered in. You can't, there is no common law marriage in Pennsylvania anymore. This is particularly difficult situation if you've got unmarried couples who are living in a home owned by the person who passed away. Now, all of a sudden, your significant other is without you and has to move out of the house because the house now belongs to either your children or your parents or somebody else in the line of intestate succession. Very difficult situation indeed. Stepchildren, also a problem. You know, I think we all, or many of us might know a situation where somebody has raised their stepchildren or consider their stepchildren as their own. They've known them for a long period of time. And oftentimes, whenever I'm preparing a will for somebody in that situation, they want to treat their children and their stepchildren exactly the same, that they just have that close relationship with them. Well, stepchildren have no place in the laws of intestate succession, meaning if you don't have a will, your stepchildren are going to receive nothing from your estate. They have no rights under the law of intestate succession. And that could be particularly difficult for kids that maybe have known you as mom or dad for the majority of their life and perhaps don't have another parent in their life to provide for them, and you leave them literally without any type of support, and you may not want that type of a situation to happen. Single parents, really, really important to have a will. You have to really be asking yourself as a single parent, who manages the assets for your children after you pass away? If you're divorced or there's going to be another parent out there somewhere, would you trust your ex to manage the money for your kids? The vast majority of folks in that situation that I've dealt with over the years would say, absolutely not. That even if they have a good relationship with their ex-spouse or the parent of their children, most would not want the money to be left to that person to manage for the kids. There may be another husband or wife or girlfriend or boyfriend in that person's life that influences the spending of that money. And maybe they have kids of their own that they brought into that new relationship. And so you have no assurance that the money that you've worked hard for is going to be used for your kids to benefit them in their future. You also miss the opportunity to designate who cares for your children, especially if your ex or the other parent is absent, right, or incapable. This situation came into my family's life when um, a cousin passed away, young woman under age 30. She had 3 children, and the dads aren't exactly responsible or even involved in her kid's life. She passed away without a will, and now it's really a very chaotic situation figuring out who's going to take care of the kids, and in particular, how her estate is going to be managed who's going to be making spending decisions for those kids. And unfortunately, what's going to happen is that money is going to be placed into an account, and whoever is caring for that children is going to have to go to court every time that they need money for those kids and seek approval of the court to spend money between now and whenever those kids are 18 years old. That's very time consuming, and it also brings the court into your kids' lives in a way that you may not really want. You might prefer that somebody that you trust manage that money, and you've set about your own priorities for how you want that money spent for your kids. Now, the court sets the priorities for your children. The court is going to be involved in making decisions about how your money is spent on behalf of your children. I can assure you that's not something that you want to have happen, and it's not really something the court wants to be involved in as well. But without a will, that's the situation that you have left for your kids. Single people with no kids. I have a daughter in that age group, living in Chicago in her early 20s. She may think that she doesn't need a will. But again, you have these questions. Who handles your estate? There are a lot of young people that are working, that have great jobs, that are saving money. They have a car, they have a bank account, they have maybe building up a little bit of retirement. There are certainly reasons for young unmarried people with no kids to have a will. At the very least, to make a decision about who is going to handle their estate after they pass away, that there's going to be something that needs to be done there, and there's really no good reason to leave a messy situation behind, especially for your parents. For people that are single and have no kids, but they have elderly parents, there's a hidden trap there for them. If you've got elderly parents, the law of intestate succession is going to leave all of your money to your parents. If you have an elderly parent that is dependent on long-term care medical assistance, maybe they're in a skilled nursing facility, maybe you're in your 50s or 60s and you've got a parent in that situation. If you leave money to them, they all of a sudden become ineligible for those government benefits for some period of time. And so they become ineligible. They have to spend all of your money down, and then they have to reapply for eligibility, which can be very chaotic, cause a lot of anxiety and concern for your parents. And maybe they're just not in a situation in life where they're capable of handling the complexities of all of that, and they need somebody to assist them for it. So especially for single people that are older, with older parents, dying without a will and leaving money to your parents might not necessarily be a benefit in a way that you would think. So let's talk about some easy ways to get your will started. And I'm telling you, it's really easy. If you're a Legal Shield member, you've got three choices available to you. The first is using the Legal Shield app. You can also fill out an old-fashioned paper questionnaire and submit it. We have no problem with the paper questionnaires. And for some folks, they like to fill it out and come back to it from time to time because they haven't made some decisions or they need to go get some additional information. It's totally okay. I completely get it. I love paper. And I'm old-fashioned. I love paper, so I don't have any problem with that at all. And then you can also submit a request to get your will done, typically on your provider firm's website. They'll probably have an electronic questionnaire on there for you. So for the Legal Shield app, if you're a Legal Shield member, literally getting this whole process started is at your fingertips. You can download the Legal Shield app from iTunes, Google Play, or wherever it is that you get the apps for your particular phone. And you can get started basically anywhere, anytime, day or night, weekend, weekday. You can get the ball rolling by using your app to get things going. Now, you can also use a Legal Shield questionnaire. You can request that from Legal Shield directly. If you know your sales associate who put you together with Legal Shield, they can certainly assist you in getting a will questionnaire. You can also download this questionnaire from our website. If you go to fificlaw.com and go to the Legal Shield section, you will find the Legal Shield questionnaire. There's a link that you can download the paper questionnaire or even complete the PDF version online and send it to us. It's a really good questionnaire. There are lots of questions in there. It'll sort of help you think about the things that you need to think about in order to get your wills done. And then a lot of Legal Shield provider law firms have links on their website that allow you to complete and submit a form online. And we have one on our website. If you go to fificlaw.com, there is an online form. It asks you a few simple questions that you can fill out and then click send, and it comes right to us. And you've all of a sudden, you've got the process started. But before you begin the process, let's talk about some things that you should have given some thought to. Now, if you don't have answers to all of these questions, I don't want to suggest that you not get the ball rolling. Sometimes getting the ball rolling is what gets you moving to get things done. So go ahead and get started, even if you don't have every one of these questions answered. And it might be that one of my attorneys can talk to you about one of these questions and help you figure out what exactly it is that you want to do. But we're going to need your basic information, your name, your contact information, date of birth. It's important for us to understand your marital status. And if you're married, we'll want to have that person's name, even if you're not cohabitating, or if you don't want that person to receive some portion of your estate. There are reasons why we need to have that information. And then we'll certainly need all of your children's names, dates of birth. It's important for us to understand that. If you're married and you have a prenuptial or postnuptial agreement, that's going to be a special planning situation. It's important for us to know that, because those agreements have probably spoken to how you and your spouse want your estate plan to happen. It's going to have an impact on that. So we're going to probably need to see a copy of that so that we can put a plan together that's appropriate given the agreement that you've already entered into with your spouse. If you have children or anybody that you want to leave money to out of your estate who is mentally or physically disabled, special needs type of a situation, we'll want to talk with you a little bit about that as well. And we can do some special planning in your will to make sure that the money that you leave for that person does not disqualify them for receiving any government benefits that they already receive that have a resource eligibility component to them. Again, we wouldn't want you to leave money to them and make them ineligible for those government benefits. That can be a real hardship for them. There are ways that you can leave money to them in a special type of a trust, and then that money can be spent on their behalf without disqualifying them for continuing to receive whatever government benefits that they're currently receiving. And we'll certainly want to know whether your citizenship status, whether you're a citizen or a green card holder or otherwise. You'll need to think about who that person is, that person of trust, who is going to handle your estate after you pass away. For most married couples, the first question is easy. It's going to be your surviving spouse. And if you have children, it might be one of your children who is appropriate to do that. But if you don't have children or you're not married, then that decision can be a little bit more difficult to make. But it's going to need to be somebody that's trusted in your life situation, and ideally not somebody at your same generation. So you wouldn't want to pick an older sibling, for example. That person may not be around to take care of your affairs, or may not be capable of taking care of your affairs if you were passed away. Very important decision, guardian for your children. I know that was a very important decision for my wife and I, to make a decision. Who is going to take care of our daughters if we were to pass away? Who will they live with? Who understands the lifestyle that we live and the priorities that we have for our children's lives, and is going to raise them in the way that we want them to be raised? Also, it's important to think about a trustee who will handle the money for your children or for anybody else that you're leaving money to that's of an age or in a life situation that you think it would not be appropriate for them to have access to that money at this time. And we typically suggest that the person who handles the money is not the same as the person who handles your children. It's usually good to have a couple of cooks in the kitchen, so to speak, to create some breaks there and some accountability. Very important set of decisions. We also need to have an idea of what types of assets and debts that you have, but particularly assets. Debts aren't quite as important. And so we try to get some very basic information about the types of accounts you have and their relative values. Knowing the numbers down to the penny, not important for us. Approximations are totally okay, but it's helpful for us to understand what assets you have, and especially to identify assets that might be controlled by that beneficiary form that we talked about earlier, because that tells us that we have some additional planning to do beyond just preparing your will. We may also have to help you prepare new beneficiary forms for you to send to your life insurance company or your 401k custodian or somewhere like that. If you have out-of-state property, important for us to understand that. Out-of-country property, particularly important as well. And then if you have specific bequests, if you want your jewelry to go somewhere, or maybe you own guns or tools or something else like that, or maybe you have a charitable bequest, we'll want to have some information about your desires in that regard. So once submitted to us, here's what happens. So you'll send that in to us. We're going to you may want to talk to us, and we're going to want to talk to you about your estate planning situation. And every situation is a little bit different. There really are no cookie cutter situations. Some are relatively the same, but they're all relatively different. We've over the last 10 years, we've prepared easily in excess of 17,000 wills for folks. And I'm telling you, we've seen just about every planning, every family situation that you can possibly imagine after doing that many estate planning engagements. We've seen just about all, but I'm sure that we haven't seen it all, and there's something new probably coming in today, so to speak. So every situation is a little bit different. So we're going to want to talk to you about your situation, and we'll probably need some additional information. The Legal Shield app doesn't ask all the questions that we're going to need to know. Maybe our online form doesn't quite ask everything that we need to know, or maybe that you can't answer a question whenever you submit those things to us, and we have to have another discussion with you about those things. So once you send all of that information into us, whether it's partially completed or fully completed, we're going to open a file, which we call an intake on our side, and then you're going to receive a confirmation email or text or both telling you that we've received your request to have your wills done and that we're going to be in touch with you. So you'll know whenever we have received your paperwork. We'll confirm it. You're going to most likely receive a call or a email, or somehow somebody from my office will reach out to you and get additional information, clarify things that we don't quite understand. Perhaps if you're like me and your handwriting is terrible, we might have to figure out whether an O is an A or an I is a T, whatever it is. We're going to just want to make sure that whatever you've sent to us, that we completely understand exactly what you've put down on the paperwork or in the questionnaire. Our attorneys, once all that information is gathered, your request goes to one of our attorneys to review and start preparing some documents. You're going to have a consultation with an attorney in my office in the vast majority of situations. I think we call everybody to make sure that you have an opportunity to ask whatever questions that you want to ask about your estate planning situation. Once we have all the information that we need, then we prepare the documents and we send it out to you. And that's going to take about 5 business days. And when we send the finals out to you, it will come out to you with instructions on how to sign everything. We suggest that you get these documents notarized, and so we're going to provide instructions to you on how to notarize them. We are working on remote notarization, and so we hope to be able to extend that service to you, that we can notarize your documents remotely through like a Zoom type of a session where we watch you sign the documents and then we can affix a notary to them. So that's going to be something that technology will allow us to do for you in the very near future. So once all of that is done, you're going to have a nice estate planning package. We recommend that you get your financial powers of attorney and your healthcare powers of attorney done at the same time that we do your wills. All of those things are things that you're going to need, and a power of attorney in particular is an important document for you to have in the event you are temporarily unable to handle your financial affairs on your own behalf. That's really, really important thing for you to have. So make sure whenever you do submit a request to have your wills done, that you also ask us to prepare your financial power of attorney and your healthcare power of attorney or advance directive. I don't want to end without talking about a few special situations that require some special planning. And the first of those is children with special needs. And we've touched upon this a little bit earlier. If there is somebody that you're leaving your estate to that has special needs, we were going to want to know that, and we will put a trust together inside your will that comes to life after you've passed away, and that the money that is intended for that special needs person will go into that trust and it be administered for their benefit during their lifetime, and it will not cause them to be ineligible to continue receiving any types of benefits that they receive already. So that's a real important situation for us to understand. High value estates are going to require some special planning as well. So if you have an estate that's in excess of $5 or $6 million, we're going to want to know that, and that includes life insurance, the death benefit of life insurance. That means that you have an estate that could potentially be subject to federal estate tax, which is a very high tax rate. We'll want to have you talk to one of our special estate planning attorneys about doing some advanced estate planning to make sure that your family doesn't receive your estate less federal estate tax. There are some things that we can do for you to plan for that. If you already have a revocable trust or a living trust of some kind, we're going to want to know about that as well, because your will probably have to pour into or pay out to your living trust at the time of your death. Or maybe you just want to get rid of your living trust altogether because it's no longer relevant for you. We can prepare living trusts, and we do prepare living trusts for folks. That's not part of the basic will benefit of the Legal Shield plan. And they're appropriate for folks who maybe have property in multiple states. That's something that they might want to have done, or they desire some additional privacy. They want to keep their estate out of the potential your will gets filed with the probate court. You may want some privacy in that regard. You may not want the probate court to be involved in the administration of your estate. It can cause some delays. It doesn't have to, but it can cause some delays to go through the probate process. And so some folks have a desire to avoid that. Maybe they're planning on moving to a different state at some point in the future. I have friends who have moved recently to South Carolina. So having a living trust can give you some level of certainty to know that that document might be able to go with you wherever it is that you go and still be valid, although we suggest that if you do move, that you have your provider law firm review those documents for you to tell you if there's any changes that need to be made in those documents. So that's the presentation for you today. I'm going to answer a few questions. Of course, I have to give you this obligatory legal disclaimer that this is general information. It's not really intended for specific advice. If you have specific questions about your estate or your estate plan, you really should call your Legal Shield provider law firm. They've got some great attorneys out there who are waiting to answer your questions. So I see we have some questions in the chat. Let me answer a few of those while we still have some time. Okay, so Claudia asks, is the trust inside the will covered with the membership or at a discount? That's a great question. Thank you. The answer is most of the time, yes. For the vast majority of folks that we prepare wills for, the trust that would be covered by your basic benefit is going to be a trust for minors. So if you're like me and you've got kids, my youngest is 13, my will has a trust that says that she can't have start having any access to that money until she's at least 21, and then maybe it gets paid out over a period of time. And before she's 21, I've got a trustee named in my will and I tell that trustee, this is how I want you to spend that money on behalf of my daughter, to pay for her college, to pay for extraordinary medical bills, to buy her health insurance, do all of those things that she needs. That money is going to be spent on her behalf for that period of time. And then the other type of a trust that we would typically put in a will at no additional charge is for special needs persons that we just talked about. Now, there are lots of different reasons for trusts and wills. And if it's a trust that's for federal estate planning, that is something that would be covered under the preferred member discount. But for the most people, yes, the trust is going to be free, no additional charge. Claudia also asks, who decides who will be the guardian for the children? That's the parents, right? The parents decide that. Now, if you pass away and you've got a surviving parent, that person's going to be the one who takes care of the kids, of course, but that doesn't necessarily mean that person's going to be the one who takes care of the money that you have left for your children. That person who handles the money can be called the guardian of the estate of the minor or the trustee if you've set up a trust. Very important to set that trust up and designate that person to spend the money that you left for your kids. Again, most people would not want their ex or the other biological parent to be the one who handles all of that money. Tony Whiting, wow, great info. Thanks, Tony. I appreciate that. Really appreciate that. Will asks, what's the difference and benefit of having a trust instead of a will? So what I am guessing is Will is asking it about a revocable trust. We suggest that a will is appropriate for 95% of the folks out there. It's inexpensive to prepare. Once you prepare it, it pretty much doesn't need to be changed over time unless there are some circumstances where it can be changed, but it's going to be a rock solid for you for a while. You know, a revocable trust is going to be more expensive to prepare to begin with, and it's going to require a lot more management and diligence during your lifetime because that trust controls assets that you have transferred or titled to the trust. So once you prepare that trust, you have to literally retitle all of your assets into the name of the trust. So you have to go to your bank and say, change my bank account from Mike Fiffick to Mike Fiffick as trustee of the Mike Fiffick Revocable Trust. You have to prepare a new deed and transfer the deed to your property or properties into the trust. You have to transfer your 401k plan, your IRA. Everything that you own has to be retitled to the trust, right? So that's a lot of work to do at the very beginning, and it involves extra expense because you have to prepare the deed and do all of these other things. You also are going to have to be diligent during the balance of your lifetime to make sure that assets that you acquire, like your new car or another bank account that you open or whatever it is, make sure that all of those assets are titled to the trust. Many folks just aren't diligent at getting that done, and they invariably pass away with some of their assets in the trust and some not in the trust, and they have to open an estate anyway. So, you know, there may be some special reasons why folks want a revocable trust that I had mentioned before. We're happy to talk with you and figure out whether a trust is the right thing for you. Bill asks, will the recording be available for us? Yes, we are recording this session and we will post it for you, and we'll let everybody know where to find that. Okay, let's see. Tamira, am I pronouncing that correctly? I hope. If you're married and jointly own your home with your spouse, if one of you pass away, does the other spouse automatically get to keep the house? Yes, the answer to that question is yes. If the home is jointly titled to your spouse, they become the sole owner of the home. If there are stepchildren involved, does that house now come into question? No, I mean, if it's jointly titled with your spouse will now own the home and the kids really aren't involved. So if you are married, but the house is still just in your name, just because you're married doesn't mean that your spouse gets the house. You have to have retitled the property in the name of you and your spouse, or you have to have a will that says my spouse gets the house. Just because you get married doesn't mean that that automatically your spouse gets your entire estate. That's something that folks sometimes don't understand. Rhonda Okamoto. Hi, Rhonda. How you doing? You want to confirm that Legal Shield law firms write new wills and not update old wills. Well, we do update old wills. If you have an old will that you want us to update, we're happy to do that for you. Noemi, do we do that as part of the basic benefit? I think we would probably do that as the basic benefit at no additional charge. It might be that you just want us to republish your will and redo it. And that's typically what we suggest that you do. It's just as easy to republish your will rather than update your will. We don't like codicils. That's what they call like an addendum to your will. Those are just complicated and oftentimes confusing. So we would typically recommend that we just republish your will.
Yes, Mike. Typically, we ask the member to fill out a new questionnaire. Life circumstances may have changed, and with their benefit, they're entitled to one free will per year. So we just ask them to fill out and start over.
Right. Noemi says that if you live in the Pittsburgh area, not only are you lucky, but you also can get your documents notarized at our office for free. Although we love Philly too, and Harrisburg and Erie and Wilkes-Barre and Reading and all of those places. Noemi in particular loves the Reading area because that's where her family is. So a great shout out to them. We are working on remote notarization, and we hope to be able to offer that to Legal Shield members wherever they are. Mitchell asks, paid off mortgage, married couple only in one name in Pennsylvania. Is there risk in not being in both names? Yes, I think we just talked about that. If it's just in one person's name and you don't have a will, it's not going to your spouse. So he or she may be pretty ticked off if you pass away and that person has to sell the house because it goes to their kids or somebody else that they don't know, and they get booted out of the place that they've been living in for a long time. So again, if you love your family, if you love your loved ones, it's really important to have that will to make sure that they're taken care of. Claudia, if no will, who decides for the care of the kids? The court decides ultimately the care of the kids. I don't think anybody would want the court making decisions for their kids. So please don't do that to your kids. Maria asks, appreciate the time. Thank you. Appreciate that, Maria. Very kind words. Living trust, better off than will. I think we've talked about that. I think that's really something that we would want to talk to folks about to see if it's appropriate for them in their situation. How does marital debt fit into the estate planning? If a spouse comes into the marriage with debt, are both responsible? No, they aren't. A spouse is not automatically responsible for the debt of their spouse unless they've co-signed for the debt. So if you've brought debt into the marriage and it's your own name and you pass away, your estate is going to be burdened for the debt, that's for sure. So whatever assets that you've left to pass to whomever at the time that you pass away, your creditors are going to be able to make a claim on that money. But if your estate is insufficient to pay those debts off, your surviving spouse will not be responsible for that debt. In PA, is it required to have a notary or is a signature sufficient? That is asked by Kirsten. You can have a will that is not notarized and it's valid. You can literally write something on the back of a napkin and sign it, and it could potentially be offered for probate and be valid. Now, I don't recommend that, right? That's not a good idea. That's a lot of risk to be taking for your hard-earned assets. So, that wouldn't be the best idea. We strongly recommend that you have your will notarized, and here's why. When you have it notarized, it becomes what's called a self-proving will. So wills that are not notarized but are witnessed, right? Or even wills that are just signed by you and not witnessed. In order to probate them, you have to have those witnesses say that they witnessed you signing that will and that in fact is your signature, okay? Well, if you prepared a will 35 years ago and it was signed by two people whose names we can't read, whose addresses are not on the will, you might imagine how difficult it is to find those people to come in and say, I saw Noemi sign this will 30 years ago. It's like virtually impossible. So then we might have to scare up what are called non-subscribing witnesses to say, I know Noemi, I've seen Noemi sign documents, I've seen her signature, I'm familiar with it, I've looked at this will, that looks like her signature to me. That is just a process that we have to go through. It takes time, it's expensive, it can be difficult to do, and you can avoid all of those hassles for your family. Again, it's not your problem, you're passed away, but it's a problem for your family. You can avoid all of those hassles by having your will notarized properly, so that all we have to do is take that will down with the other documents that we need, and wham bam, the estate is open, and all of a sudden we're administering your estate, getting those assets to your family. So same thing with the power of attorney. They do have to be notarized in order to be valid. Powers of attorney are really particular documents, and banks and other financial institutions in particular are, they really scrutinize those, and you want to make sure that those are completed 100% appropriately, and getting them notarized is a big part of that. Your advanced director for healthcare and living will don't have to be notarized, but they should be. Again, I think it's just advisable to get them notarized if it's at all possible. So any other questions for anybody? I want to be respectful of your time. We're just about at that hour timeline there.
Yeah. Mike.
Is that Bill? Yes.
Yeah. If you move to another state, we keep our membership. Would the next firm go over our wills to make sure they're appropriate for that state?
Yes, that's a good question. And absolutely, if you move to a new state, you should ask the provider, your new provider law firm, to review your wills to make sure that they are valid in your state. That's a very, very good idea. Just because you move doesn't mean that your will will not be valid, but it's a good idea to have them do it. Any other questions that I can answer for anybody? Hey, Tony, is that your house behind you? That's what I want to know.
That's the dream house, Mike. That's the dream house.
I love it. I love it. It's beautiful. That's a beautiful dream you've got there.
Hey, Mike,
Arizona bound.
We have another question pop up in the chat.
Who would you recommend to be the trustee, if not a sibling or a peer? That's a great question. A lot of people struggle with trustee decisions. So, it's obviously somebody that's trusted in your life, that's going to be able to, that has the ability to handle financial affairs. So, it can be a person. I'll say this about a trustee. The most important characteristic in a trustee, in my view, is the ability to say no, because they're going to be having somebody ask them for money, and that can be a very tough thing to be asked. And people might be persistent about it, really persistent about it. You have to have the ability to say no. Now, if you can't find somebody in your life that it has the qualities that would make them appropriate for a trustee, there are trust companies. Most banks will have a trust division of some kind they're professional trust managers. They do this kind of a thing. Trust companies typically are going to want an account that has a minimum amount of money in order for them to be the trustee. And I would say that's probably at least $250,000 in a trust. So you've got that impediment about picking a corporate trustee. Corporate trustees also charge fees, and you have to understand that there's a price to pay to get professional management of the trust. And they can sometimes be not the easiest to deal with. So if you're thinking of naming a corporate trustee, and that's perfectly appropriate, 100%, I recommend corporate trustees from time to time to folks, because they provide there are complicated situations where I wouldn't want to be the trustee either, because it can be tough. It can be a real hassle to deal with folks asking you for money all the time. Claudia, if you're raising your hand, hang tight. You want to shop around for a trustee and interview them and ask them, what's it really like to deal with them? How it is, what your beneficiaries are going to experience whenever they ask for money or need money, and what's the decision-making process. You can also have a co-trustee situation where you pick a person and a professional trust management company, and they sort of work together. So, Claudia, do you have a question?
Yes, I do. I don't want to beat the dead horse here, but two people are married. They have children. Only one name on the house. the owner of the house dies, I'm guessing the intestate succession would step in. So the children would be beneficiaries of the house, and then the deceased person's parents.
Okay, so you've got a married couple with, and the house is in one person. The house is in one person's name. That person dies, right? Okay. No will. The law of intestate succession says that your surviving spouse, okay, is going to get some portion of the estate, and it depends on whose children they are. So if it's the child of the surviving spouse gets the first 30,000 and then 1/2 the remainder. If the child is not the child of the surviving spouse, then the surviving spouse gets 1/2 of the estate. So you can imagine in a situation, I'm hearing myself talk. Sorry about that. But you can imagine in a situation where the house is the primary asset in the estate. In order to satisfy that 1/2 that's owed to the child, the house might have to get sold. I mean, it'd be really terrible to pit your surviving spouse against your own children in an estate. So you definitely don't want to do that. And you especially don't want to do it if you've got stepchildren. That can really be tough, especially if it's not a comfortable blended family. I've had to deal with that, and it's really difficult. Any final questions? All right. Well, seeing and hearing none, I thank you all very, very much for joining us today. We really appreciate it. If you've not gotten your will done, send us your wills, questionnaires, or your apps, or whatever it is, however you want to get it to us. We try to make it as easy as we can. And if you're a sales associate, please encourage your members to get their wills done. We will take care of them if they get their requests into us. So thank you again.
They have the ability to text.
What's that, Noemi?
They have the ability to text us as well.
Yes, that's right. You can text us right off of our website. So no excuses.
Hey, I
Thank
do
you,
have
everybody. Oh, go ahead.
one more quick question.
Is that
The
Maria? Yes.
estate- Yes, it's Maria, sorry. The estate planning or the probate benefits, so if I have a will, my husband and I die together, it's our benefit. Who gets that benefit? It's like 6 hours. Who has to be a member to be able to get that benefit?
Well, I believe that the probate benefit does apply to your estate. So whoever your personal beneficiaries would be the one who would access those benefits on your behalf.
Okay, so that would be a good thing for us to tell people that they have that access.
Yes, that's the Primerica probate plan. So not everybody on the call probably is familiar with that, but that's the Primerica product. Yes.
Okay. Thank
Okay.
you.
Hello?
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 Well, I don't think that's us. All right,
Thank
everybody.
you.
Thank
Hello?
you.
Oh, wait a minute. Hello? I just came on.
Oh, okay.
Hi,
ahead.
my name is Ty. I just came on.
Hi,
I had
Ty.
a problem with my volume. Question, let's say if I didn't plan yet and something was to happen and it's just my daughter and my granddaughter, or what happens?
Well, as a single individual, right, your daughter is entitled to your estate, right?
Mhm.
But you've not designated who will care for your daughter if she's a minor. So that's a big open question.
Mhm.
And if she's a minor, you also have not designated somebody to spend the money on her behalf. And so somebody will have to file a petition with the court to be appointed as the guardian for your daughter and or for the money that you've left for her. And it will not be her mother, because the
Okay.
court will not appoint her mother. It'll be some person that you don't know. And I'm sure that that's not what you want. You would not want to leave that decision, that very, very important decision, to the court. And who knows who will come out of the woodwork to say, that I want to take care of Ty's daughter and I'm appropriate to spend her money. And then that person will have to file annual reports with the court until she's 18 years of age. You may not want her to have the money at 18. So there are lots of really important things that you can resolve by having a will. So folks with kids, especially minors, super important to have a will.
Okay.
Does that help?
Yes.
Okay. Thanks
All
for
right.
joining, Ty. I appreciate it.
All right.
All right, everybody, take care. Bye-bye.
All right.